We're ready to go, Rob. Good morning. Welcome to the licensing hearing for the variation of a premises licence at 5 Whitmer Watmagate. I understand that Councillor Melly has been appointed as chair for the hearing. Can members confirm that this is the case and that they're happy with that?
Yes, that's right.
All right, great. Thank you, Angela. Right. Good morning, everyone. Welcome to this licensing hearing. Sorry for the slight delay to the start time. Technical issues happen. So thank you all for your patience. And yeah, let's get cracking. The meeting is being live webcast, so people can watch online at home, and it's also being recorded and will be available to watch later as well. So agenda item 2, introductions. We'll just make sure everyone knows who's who. So there's 3 councillors on this panel. There's myself. Hello, I'm Councillor Melly. We also have Councillor Galvin and Councillor Wells. So the 3 of us make up this hearing panel. We also have some council officers with us. We have a licensing officer, Leslie Cook, democracy officer, Angela, and our solicitor, Sandra Brannigan, is here as well. The applicant, Mr Simsek. Hello, good morning. You're here. Do you have anyone with you, a solicitor?
Yes, John Walker there for me.
Good morning, John Walker. And then representatives. We have a representative from the police, PC Kim Hollis. You're here. Good morning.
Yeah.
Hi. Public protection, Michael Golightly.
Yep. Hello. Good morning.
Good morning. And from the licensing authority, Helen Sefton.
Hello, good morning, everyone.
Morning. Okay. I think that's everybody just looking around. Yes, great. All right. Right. Agenda item 3, declarations of interest. Do any of the members on the panel have any disclosable pecuniary interests or other registerable interests to declare? Nope, shaking heads. All right, excellent. Okay, agenda item 4, exclusion of press and public. I would like to propose that we exclude the press and public from our deliberations and decision making that we hold after this public hearing, because the public interest in excluding the public outweighs the public interest in that part of the meeting taking place in public under Regulation 14 of the Licensing Act 2003 and Hearings Regulations 2005. Can I have a resolution for that, please? Nods? Yep. All right, great, excellent. Okay, so we'll move on to the main business of the meeting, agenda item 5. The determination of an application for the variation of a premise license for 5 Whitmer Watmagate. We are only considering the variations applied for. This isn't a licensing review of any other aspects of the license. So can I please invite the licensing manager to present your report, please?
Thank you, Chair. Good morning, everybody. Yes, this is an application to vary the premise licence for 5 Whitmer Watmagate, York. The variation seeks to extend the hours for recorded music from 11 p.m. until 1 a.m. and amend conditions 2, 3 and 8 of Appendix 3 of the licence, which currently restricts the use of the door to the roof terrace and the use of the roof terrace area to 9 p.m. each day. The applicant seeks to increase these hours to 11 p.m. each day. A copy of the application and a plan of the premises are attached at Annex 1. A copy of the current licence and the plan is attached at Annex 2. This licence was originally granted in June 2018. It was granted by a licensing subcommittee, and a variation was granted in September 2021, again by a licensing subcommittee. An overview of the circumstances in which entertainment activities are not licensable can be found at Annex 3. As part of the application, the operating schedule submitted by the applicant showing how the licensing objectives will be met can be found at paragraphs 10 and 11 on pages 8 and 9 of the report. I can confirm that this premises is located within the community impact assessment area. It is not located within a red or amber zone. Section 9 of the Statement of Licensing Policy, which deals with community impact, can be found at Annex 5. The full contents of Section 9 have been published as an agenda supplement. I can also confirm that the consultation process has been carried out correctly. North Yorkshire Police have made representations on the grounds that the licensing objectives, prevention of crime and disorder and prevention of public nuisance will be undermined by granting this application. Furthermore, the applicant fails to demonstrate how the application would not add to the cumulative impact of licensed premises already experienced within the cumulative impact area. Their representation can be found at Annex 6. The City of York Council's Public Protection have made representations on the grounds that the licensing objective, prevention of public nuisance, would be undermined. Furthermore, the applicant fails to demonstrate how the application would not add to the cumulative impact of licensed premises already experienced within the cumulative impact area. Their representation can be found at Annex 7. The City of York Council Licensing Authority have made representation on the grounds that the licensing objective, prevention of crime and disorder and prevention of public nuisance, will be undermined. Furthermore, the applicant fails to demonstrate how the application would not add to the cumulative impact of licensed premises already experienced within the cumulative impact area. Their representation can be found at Annex 8. A map showing a general area around the premises can be found at Annex 9. The committee has the following options when making your decision. Option 1, modify the conditions of the licence. Option 2, reject whole or part of the application. That's a brief overview of the report, Chair.
Thank you, Leslie. Sorry to just take a step back. I should have just double checked before we started that everybody has understood the procedure that we're following today. That was included in the papers that was sent to in the agenda pack. Has everyone seen them and understood them? Yes. So paragraph 30 of that procedure says that if the decision is made today following the conclusion of the hearing, that the subcommittee will return to the public online meeting to announce the decision. But actually, we're just as a slight change to that, we're not going to do that. We'll close the public hearing when the hearing's done and close the public meeting and then go away to make our deliberations. And if we make the decision, everyone will be informed as soon as possible, but we won't come back to the public meeting. Just to make sure everyone's understood that. And the other thing I should have double checked, as Leslie mentioned, there were a couple of agenda supplements, a document about the cumulative impact area and also a noise management plan. Can I just double check that everybody has seen those? Excellent. Okay, great. So yes, thank you, Leslie, for presenting the report. There's now an opportunity, just in case anybody has any questions for the licensing manager. The applicant, do you have any questions for the licensing manager?
No, I don't know.
No, John, you don't either? Okay. Police, PC Hollis, do you have any questions?
No, thank you, Chair.
Public Protection, Michael Golightly.
Yeah, no questions, Chair.
Licensing Authority, Helen Sefton.
No, thank you.
Legal Officer, Sandra, any questions for the licensing manager?
No, thank you, Chair.
And then members of the panel, any questions? No? Okay. In that case, John Walker or Mr Simsek, you have 15 minutes to present, 15 minutes to address the panel and make your case. If you could try to keep it to 15 minutes if possible, please.
Thank you, Chair. I'll do my very best. I confirm that I act for Mehmet Simsek, the applicant in this matter. To give some background, these premises comprise a small restaurant bar cafe with a ground floor inside area, a ground floor outside area, and a first floor outside area. My client can currently sell alcohol on the ground floor inside area until 1 AM, in the ground floor outside area until 11 PM, and in the first floor outside area until 9 PM. So in essence, we're seeking to extend the hours for the first floor outside area up to 11 PM as well. That's the first part of the application. The second part is to extend the hours for recorded music that is played inside the premises from 11 PM to 1 AM. This is just to bring recorded music in line with the authorised hours for the sale of alcohol inside the property, which were increased in 2021. The background to this matter is that my client has lived in York for a long time and has run this family-owned business himself in the centre of York for a number of years and has done so successfully. He's built up a very loyal clientele and has always run a very tight ship. He employs a lot of local people, 17 in total at present, and is managing to survive in these very difficult economic times in competition with large operators with no real interest in the city of York. Mr Simsek is a conscientious operator. He does not want stag do's or hen parties, and he often closes the premises if there are large sports matches or on race days. This is not the kind of business that he's trying to attract. His aim is quality, not quantity. I hope that I'll be able to convince you that the way that Mr Simsek runs his business is such that you feel able to grant this application, and he is here today to give evidence in person if required. However, I do only have 15 minutes, so I'll move straight on to the law that's involved. As already stated, this property is within the cumulative impact area, but is not in the red or amber zones. The City of York Council issued a statement of licensing policy for the years 2022 to 2027 earlier this year, and have also issued a document headed the Cumulative Impact Assessment 2022 to 2025. My client's been supplied with copies of these documents, and this application has been lodged with these documents very much in mind. It's clear from the statement of licensing policy that the onus is on the applicant to demonstrate through the operating schedule that he intends to take. So you can be satisfied bearing the license will not add to the cumulative impact already being experienced. This is paragraphs 9.9 and 9.10. What has not been mentioned so far is paragraph 9.15, which indicates that a variation may be considered more favourably if a number of conditions are met. And I'll run through these conditions. Firstly, it's a help if there is no vertical drinking, i.e. all customers are seated at tables. This is the position here and will continue to be. There is no vertical drinking. Next, table service only with no customers at the bar will be looked upon favourably. Again, my client fulfills this condition. Thirdly, there should be a set number of table covers. Once again, my client can comply with this. A specified number of covers is 45 for inside downstairs, 30 for upstairs outside, and 20 for downstairs outside. Next, there should be no drink promoted in line with food promotions. Again, nothing of that nature in my client's business. And finally, under 9.15, it helps if a business is food-led and if alcohol is sold ancillary to a meal with substantial food, and that this food is served during the duration of the operating hours. A proper food menu is available here right through the day and evening, and the vast majority of my clients' customers do have proper food with any alcohol that they drink. Last food orders are taken at 10 p.m. Before I consider the specific steps that my client is taking to ensure that there are no adverse effects in the cumulative impact area, I'd like to make the point that he already complies with an extensive raft of requirements. He has a modern and comprehensive CCTV system that covers the whole building, including the first floor. He also has a system to monitor noise, radio contact between ground floor and first floor, signs requesting customers to be quiet when they leave the property, and all the relevant logbooks, etc. However, he does realise he's taking on an extra responsibility now and has spent a lot of time preparing a noise management plan. The latest version is among the papers submitted at Agenda Supplement A, as already mentioned. I'd be grateful if this could be considered carefully. There have been some further discussions between my client and Michael Golightly. No doubt Michael will be able to confirm what's been said. and a site visit has taken place. I understand that the noise management plan may need altering slightly after this visit. My client's happy to do whatever is required to secure a satisfactory outcome. For example, I'm told there's going to be a 70 dBA limit rather than a 90 dBA limit, something mentioned on the final page of the noise management plan. Further, my client has added a second internal entrance door at the premises to reduce the chance of noise escaping. Do bear in mind as well that the first floor terrace can only be accessed via this one entrance, and that you must go across a heavily manned ground floor to get to the internal stairs leading up to the first floor terrace. You can see from the noise management plan how seriously my client's taking this whole matter. Because of this, and because he's very mindful of the need for the proper supervision of the first floor terrace, he's organising extra training for his staff. I must say in the strong that this training will stress there will be zero tolerance of any excessive noise at all. He's also happy, if it is possible, to have a condition added to the licence to the effect that there will always be at least one member of staff present in the first floor terrace area if there are any customers up there at all. In fact, under current arrangements, there's always at least one person in that area, and on many occasions in excess of one, 2 or 3. Turning to the representations that have been made, the first thing to say is that there is only one residential property in the vicinity of the first floor terrace, and this is not immediately adjoining the property. Further, there have been no representations made by anyone other than the public authorities. In other words, not a single member of the public has objected here, not one person. A point's been raised by the police in relation to the ground floor plan, and this has been noted. A new plan of the ground floor will be lodged shortly, but this is not directly relevant to the hearing today. The applicant is happy to put up a barrier on the side of the property that faces the one residential flat in the area, subject to City of York Council consent. In addition, he has a pending application for a large awning on the first floor terrace, which would help to reduce the passage of sound further if successful. I'd like to conclude by putting this application in context. My client can already sell alcohol in the ground floor outside area until 11 p.m. This is only a few yards away from the first floor terrace. He's in a part of York where there are literally dozens of much larger and noisier licensed premises, many of which are serving outside until at least 11 p.m, and many of whom are open well into the early hours. For example, in terms of the Terrace Sports Bar, the premises license there is until 2 a.m, and the terrace can serve outside until 11 p.m. That property is only a few yards away from my client's premises. Mr Simsek is a small independent operator who runs a successful business by putting in long, hard hours himself, as do other members of his family and his closely knit team. He's there every day from first thing in the morning until last thing at night. He and his business are a credit to York. Apart from one single noise complaint that was caused by an error that will not be repeated, he's never had a complaint made or been involved in any trouble of any kind whatsoever. In my submission, the extension of the license hours by just 2 hours for a first floor terrace that can only accommodate a maximum of 30 people, all sitting down and with table service only, is not going to have any effect whatsoever on the cumulative impact area or adversely affect any of the 4 licensing objectives. In these circumstances, the extension of hours for the first floor outside area from 9 p.m. until 11 p.m. is a perfectly reasonable request, particularly bearing in mind paragraph 915 of the council's own licensing policy, which is set out on the last page but 1 of the pack if you'd like to see the actual wording. To confirm so far as the second part of the application is concerned, this is simply bringing recorded music timings in line with the authorised hours for the sale of alcohol within the building. Chair, those are my representations. Let me know if I can assist further, or if you'd like Mr Simsek to say anything on his own behalf, or if anyone has any questions for him or for me. Thank you.
Thank you very much for that representation and for keeping it concise and relevant to the application. Yes, thank you. There is an opportunity for questions now. We'll go, yes, in the same order of representatives that we have been so far. So we'll start with the police, with PC Hollis. Do you have any questions for the applicant?
Thank you, Chair. No questions from me at this time. I shall cover it in my submission. Thank you.
All right, thank you. Michael Golightly from Public Protection. Do you have any questions for the applicant?
No, thank you, Chair. I'll be okay. Thanks.
All right, and licensing, Helen Sefton.
No questions, thank you.
And members of the panel, questions for the applicant? Yes, Councillor Galvin. And then Councillor Wells, I've seen your hand.
Can I just understand how far, I realise I'm not to a few yards, how far the nearest habitable property is and how far the next block of habitable property? I know the area reasonably well, but I don't know what residential properties are around that area. Could you give us some idea of distances from, certainly from the outside area, please?
The only flat or the only residential property is a flat in the back of one of the buildings on Shambles that faces outwards towards the property. Apart from that, I'm not aware of any residential properties anywhere nearer than Stonebow House and the houses on St Saviour Gate, which are some considerable distance away. All the other properties, so far as I'm aware, backing on from Shambles, are not residential properties.
Thank you.
So on page 73 of the papers, there is a map of the area, so you can see where the Shambles is and the properties on it in relation to the application site. Councillor Wells, you had a question for the applicant?
Yes, thank you, Chair. In your submission, you mentioned zero tolerance to noise. Can you tell me what that means and whether or not that's been exercised in the past, please?
Perhaps my client could make some comments on that. Mehmet,
Yes, hi.
You about zero tolerance of noise?
Yes, well, I am personally here from opening till closing time. Anything and in same time, I've been in this building before the restaurant as a hairdresser for altogether about 17, 18 years. So I have known in the area since I've been running the place. I am asking all my neighbors anything is irritating them, any complaints they got about the way I run it, they are all okay, including the nearest flat we got behind, and also for upstairs. And I would not allow anybody ruin mine, my children, and 17 of my staff's future because of anybody's stupid act. This is very, very important for me. This is my livelihood. I am not millionaire. I'm not just going to decide and go elsewhere tomorrow later on. This is my livelihood. So therefore, it's extremely important for me to work with the council, with the neighbors of mine. So I am always on it. I got all these radios, two-way radios. If I'm staying a bit longer, you know, longer hours, I got door stuff at door, and I am always on it. So obviously all of you live in York. If you go past from here, you definitely see me. First thing in the morning, I come here at 6 o'clock, wipe and sweep the area. I do that at night. I open my shop, I close my shop. So it's very, very important for me. That's my answer.
Thank you, Mr Simsek. Any other questions, Councillor Wells or Councillor Galvin?
No.
Okay, I have a couple, if that's all right. Where to make a note of them? Yes, so you mentioned being willing to put up a kind of screening barrier between the upstairs outdoor area and the nearest residential property. But is that something that requires some other sort of permission, planning permission or something before you can actually install it?
Yes, we think it does need planning permission, and the matter has been referred to Mr Simsek's planning agent.
Yes.
Okay.
I will gladly do that. No problem whatsoever. I work with you 100%.
Yeah, but I think it does need some kind of planning consent.
Yes. Yes.
Just doing it.
Yes,
Okay.
we'll be doing it as well.
So, I mean, we need to look at this application as it is in front of us. Is there, yeah, so that may be a little kind of hypothetical. We don't know if it definitely will be in place when we're looking at the impacts of this application. Is there any other sort of screening at all between that terrace area and residential properties?
No, I don't have anything at the moment. No.
No other screening. Okay.
Well, we are usually using this in summertime. We'll be using summertime. At the moment is winter. By then, application will be on.
And you mentioned being willing to have a member of staff in that terrace area at all times when there are customers there. That isn't currently in the noise management plan, but if we were minded to grant the application, is that something that you would be willing to have as a condition?
Yes.
Yeah. Okay. Also in your representation, you mentioned, well, you referenced licensing applications and considerations of no vertical drinking and being food led and alcohol being ancillary to food and that sort of thing. But there actually isn't currently a condition saying that so a substantial meal has to be served with alcohol, or that I think you're opening until 1 AM, but you stop serving food earlier than that. Is that right? So there is some drinking without food.
That's right.
So it's not necessarily a food-led establishment, is that, in terms of conditions or how it could operate? Is that?
Well, not necessarily, but it's not bar only place. It's mainly customers are over 30 to upwards. They are here, they're having a meal, and they stay, they stay for the relaxing a good time. And I've been in York since 1990. Most of the people I know in York, that they told me that they are wanting somewhere that without getting pushed and waiting on the queue to get a drink, somewhere they can sit, somewhere like my place, then they can sit and relax without getting pushed and everything, which I got crossroad. There's a tax rank there. They can live here nicely and quietly. So it's perfect place for me. And I got no problem with nobody at all. I never been in police station before. We never had no problem in my provinces, and I wouldn't allow.
Thank you. And I think my final question is about the nature of the music on the premises. Do you currently play incidental music between, kind of 11 PM and 1 AM while you're open late at night, or no music at all? And what sort of music are you hoping to play?
Well, it's just it's like it depends of the custom. It's just what I mean by depends of the custom. It's background music, just relaxing music, so people can in same time people can have a conversation. which you had a little conversation with Mr. Michael. Sorry that I forgot his surname.
Go lightly.
So he knows more or less how we do what we do. He's seen it himself.
Okay, but in terms of your application for recorded music, extension of hours of recorded music until 1 a.m., what's the nature of that music that you're wanting to play?
Same as same as it's very similar to what I do in daytime.
And that's kind of just incidental background.
Yes.
But you're not currently playing any sort of incidental or background music at the moment until during your later opening hours.
No.
You're not currently. Okay. All right. Thank you very much. Is there any other final questions to the applicant? All right. Okay. Thank you very much. In that case, we'll move on to the first representer's case. The police. PC Hollis, you have 15 minutes to make your representation, please.
Thank you, Chair. Good morning, Chair, members of the subcommittee. My name is Kim Hollis. I'm a police officer for North Yorkshire Police, working as a licensing officer for the City of York. Thank you, members, for taking the time to have a look at the representation made by North Yorkshire Police and consider the content of that. This is an application to vary a premises licence for a restaurant with an indoor and outdoor seating offer, including a roof terrace within York's Cumulative Impact Area, or CIA. The applicant requests that the following be granted: to extend the roof terrace timings that can operate daily by replacement of Annex 3 conditions 2, 3 and 8, meaning an extension from 9 p.m. till 11 p.m. 7 days a week, and the extension of recorded music from 23:30 hours to 0100 hours 7 days a week. As we know from the City of York Council's statement of licensing policy, the CIA is considered to be the area under the most stress and strain from licensed premises, leading to an increase in crime and disorder and public nuisance. I know Mr Walker's already pointed out parts of the policy, but I would just like to recap a few parts for you, if I may. 9.9 does state the applications for new premises license or variations for premises situated within this area that are likely to add to the cumulative impact already experienced will normally be refused if relevant representations are received. The applicant must demonstrate through the operating schedule the steps that they intend to take so that the council and responsible authorities can be satisfied that granting a new or varied licence will not add to the cumulative impact already being experienced. That is to say that they are adding to that overall cumulative impact, not just this one premises, but the overall within that area. And 9.10 rightly does say the onus is on the applicant to demonstrate that. I will highlight 9.15 to you, as Mr Walker already has, and I will read from the policy itself. Applications for the grant or variation of a premises licence in the cumulative impact area may be considered more favourably if the applicant can demonstrate through the operating schedule that the premises is going to be predominantly food-led, with alcohol being sold or supplied ancillary to a meal with substantial food, being served throughout the duration of operating hours, no vertical drinking and all customers to be seated at tables, a set number of table covers, table service only and no customers at the bar, and no drinks promotions unless they are in line with food promotions. As you've rightly pointed out, Chair, some of these conditions are lacking within the existing licence and in fact within this application that's in front of us today. The premises was granted a licence in 2018, at which point the licensing subcommittee saw fit to restrict the operating hours and that of the roof terrace to not allow its use after 2100 hours. The premises opened and operated under this licence in late 2020, to my understanding, and due to the coronavirus pandemic, experienced a period of closing shortly afterwards and restricted operating from some time after this still. An application was submitted in July 2021 to extend the hours for licensable activities and remove the conditions relating to the roof terrace. North Yorkshire Police submitted a representation in relation to the variation, as well as representations being received from other responsible authorities and residents. It was noted in a visit to the premises at the time that the plans for the layout of the premises did not match the interior layout when we visited. As a result of representations received, the applicant withdrew all changes relating to the roof terrace at that time, and as such, representations from responsible authorities were also withdrawn. The applicant has now applied again for a variation to the premises licence, looking to extend the hours the roof terrace can be used by 2 hours, and for recorded music inside the premises until the terminal hour for sale of alcohol, meaning recorded music such as DJs would be able to perform until 0100 hours daily. Of course, we know background music doesn't apply, and they can already use background music and can have background music within the premises, but this is for recorded music until 0100 hours, 7 days a week. The premises has only operated for a limited amount of time since the licence was granted, and has already extended the hours for the sale of alcohol for a period of time where the premises is able to operate 7 days a week, and it's yet to be seen what the impact of this premises being open those hours will fully have. North Yorkshire Police still have concerns over the use of the roof terrace after 2100 hours, as this is likely to impact the licensing objectives by causing a public nuisance and allowing the premises to offer a further offer for customers who will be able to use the premises for drinks without any obligation for food. 7 days a week in an area which is already under immense pressure from the volume of licensed premises and does have nearby residents. I would argue that the residents that are situated on St Saviour Gate and the Stonebow are not a considerable distance away, but merely steps away. It's also our belief that the applicant has not demonstrated how this will not further impact the licensing objectives or provide any information surrounding the reasons why recorded music is needed at the venue. A venue which is said to be operating as a restaurant, but has already permitted the sale of alcohol till 1 in the morning, and there is no obligation for people to dine within this premises within the licence. Background music can already provided while they're still eating and drinking within the premises, and I don't feel that we've had any information as to why recorded music would be needed, just that we're being told that they want it to be in line with alcohol. It has to be said that without any conditions in place requesting the premises operates as a restaurant or has any obligation to serve food at the venue can already operate selling alcohol till 1 in the morning inside, and if granted, they may operate with service of drinks outside and on the roof terrace until 2300 hours, with customers inside listening to recorded music until 1 in the morning, 7 days a week. This would very likely increase public nuisance and crime and disorder if permitted. I think it's well understood that customers are not predominantly looking to dine in the later hours, and raises concerns as to the use of the premises in these later hours, perhaps after 10 p.m. when the food has stopped being served. Chair, members of the subcommittee, North Yorkshire Police would respectfully request that the changes applied for in this application be considered in line with your own policy and consideration be given to rejecting the application at this time. Thank you, and I invite any questions.
Thank you very much. Mr Simsek and Mr Walker, do you have any questions for the police?
No.
No questions at this time, no.
Right, thank you. And members of the panel, Councillor Wells and Councillor Galvin, any questions?
Yes, I'm frantically looking. I've read it once. It's this question of music. Now, I understand, and I think I've read it somewhere, and I stand to be corrected. Here we go. That incidental music, which is incidental to some other activity, is not licensed. Annex 3, page 55.
Correct.
Am I reading that correctly, or am I reading it incorrectly?
That's absolutely correct, Councillor Galvin. Yeah, of course, at the moment, because they are licensed and they have an operation, maybe food-led, or people are drinking in the premises to later on. Background music, music is fine.
Can I ask then what the problem is with what is being proposed at present? I mean, recorded music seems to suggest the possibility of having a DJ. Well, I mean, any incidental music is going to be recorded anyway, one would have thought, unless you've got a sort of violin trio in the corner.
Absolutely. Yeah, the difference I think really is that they are already permitted to do that incidental music. So by asking for recorded music, which really is music played at a louder level, things such as DJs, by asking for that on the license, they're asking for more than what they already have. So they're asking to be able to have that louder recorded music. So regular incidental music they can already have right now. So that's our concern, is why do they want that louder music, and what will the offer be? And we don't feel that we've had answers to that.
But technically, incidental music is going to be recorded, is it not?
Yes, but for the purposes of the Act, recorded music is the licensable activity, which I'm sure the licensing authority or Sandra may want to clarify for you. But from a legal point of view, the recorded music, the actual application of recorded music, even though incidental music may be recorded music in the Act is meant as the actual licensable activity itself. So yes, recorded incidental music, as it were, playing a tape or a CD or whatever in the background at a background level is already permitted. But if they want to have the kind of recorded music from the purposes of the Act, then it does suggest that it's going to be a louder or a more impactful style of noise. Michael will probably be able to explain that much better than me.
So if we refused recorded music, which on the face of it seems to me not what they want anyway, if we refuse that, then that would remove one objection to the application.
Absolutely, yeah, that forms part of the representation from North Yorkshire Police.
I know we're playing with words, but unfortunately, that I suppose is the name of the game. Thank you.
Thank you.
Any other questions from the panel? Councillor Wells? No. I just have a question about in terms of the impact and the operational difference. What do you feel? Do you feel there's a difference between the ground floor outdoor area, which currently is licensed and allowed, and the first floor roof terrace?
I think really what the point that we're trying to make is that that was an extension that was added on last time around within this already very sensitive area, but the council saw fit, yourself saw fit to grant that extension. And that's in place now. And of course, the granting of till 1 a.m. as well was permitted. And what we're saying as North Yorkshire Police is the cumulative impact area it's not just about how this premises behaves, it's about the overall picture of adding more and more all the time to an area already under a lot of stress and strain. I know John mentioned himself other premises that already have late licenses within that area, and that's absolutely correct. And what we're doing by adding more is we're adding more noise, more people, more drinking into an area that's already fit to burst from those things. That's what the policy says. So by adding a further section in the way of the roof terrace, which adds a point of appeal for people to come and encourages people to come out later and sit within that area as an attractive sort of point to sit in the city, it just encourages more people into the area and it adds more impact. And that's really our point. It's not specifically that it's a roof terrace, it's just that we're adding more people in, and that's the point that we're trying to make. Michael may be able to talk more technically around the noise issues specifically and about how noise carries, but from our point of view, we're just looking at it as a general overall adding to noise and adding to extra people and extra bodies.
Okay, thank you very much. Any other final questions from the panel for the police? No. Okay, thank you. We'll move on to public protection then, please. Mr. Golightly, you have 15 minutes now to make your representation, please.
Great, thank you. Hello, obviously I'm representing public protection and we're making representation against this application on the grounds of public nuisance. I'm not going to go through what the application is about anymore because we've said that so far, but I will remind you that it's in the CIU, which is the cumulative impact area. There's an area designated by the City of York Council in a statement of licensing policy where evidence shows that the cumulative impact of the number and the concentration of licensed premises continues to adversely affect residents and visitors and other businesses. This is therefore adversely affecting the promotion of the licensing objectives of prevention of crime and disorder and public nuisance within this area. Obviously, in the CIA, when applying for the license, the onus is on the premises license holder to demonstrate that the license objectives will be met and that their activities will not lead to an escalation in crime disorder and public nuisance. Public Protection's first concerns are about the rooftop area from public nuisance. Now, there is at least one resident at the back of the premises. It's about 8 metres away, and this application will be introducing more raised voices later into the evening. They're obviously having music up there as well, even if it's background, they're having music there. This will be going from 9 p.m. to about 11 o'clock in the evening. And with raised voices, no matter what you try to do to control them, they will happen. It will be sporadic. This can be more impacting upon people. Raised voices can be very loud and can travel quite a good distance, especially if there's lots of reflective surfaces around there and hard surfaces, which there are. You can't stop it completely. And raised voices as they more and drink, this will be creating a situation where you're drinking later into the evening in that area, therefore getting more and drink, getting more raised voices, competing against the music. And we have a concern about this, especially since we have had a noise complaint about music from the premises. I think especially as well, this will be happening on 7 days a week. So you'll have Friday, Saturday nights when it's a bit noisier in the city centre. However, there are other nights when it might be quieter, Monday, Tuesday, Wednesday, Thursday, and this will be introducing that then and increasing that time. There may only be one resident to the back of the premises. However, we do have to remember that public nuisance can be for one person. And the onus shouldn't be upon the resident to accept a disturbance from the premises. The onus should be upon the premises not to create a disturbance to the resident. They need to demonstrate how they're going to do this and prevent that from happening. And I don't believe that they've done that here. Also, this ignores the fact that you may go to a resident and say, is it okay if we have this music and more people speaking out here? Then that resident moves away, you get a new tenant, and you need to protect everybody in that area, as well as what's being said by the police. If the noise does reflect off the windows and the walls in that area, it could reverberate around, and you're increasing noise to the noise that's already there. That could go up St Saviour Gate, who do get a lot of noise complaints down there because of the way the sound travels. And this is all adding extra burden into this area within the CIA. This would also be setting a precedent in the CIA whereby you're allowing premises in the external area to open later. We found that this is a good time when it's so close to residents, bearing in mind that this is 8 meters away from a residential premises with only single glazing. That's a listed building that they can't put any mitigation on themselves from. This may result in creeping noise levels in the city centre, and therefore more pressure upon the CIA from a public nuisance. It would also contradict, obviously, the earlier decision that you made about this, which refused this area from being used under the grounds of public nuisance, and it would be effectively overruling that decision made upon the licensing policy that we've got in place in the city centre. Just trying to look at the next part of this. The next thing is to consider about how you manage an area. The applicant states that they're running a tight ship, and that they will be more stringent in running it once they've got this variation. The problem and the concern that we've got with this is threefold. It's an admittance of the fact that there is a pressure, that there is a risk of public nuisance being an issue here by their own admission that they're going to have to be more stringent, but it's also how effectively are they managing the site at the moment. Now, the way you can prove that is through the amount of time you've been running the premises, how you handle noise complaints, and your policy for handling and managing the site, for example, a noise management plan. Now, they opened up during the pandemic, which meant that when they've opened up, they've been closed for a long period of time. As they've come back into being open in this area, there was an understanding by residents and people in the city that businesses had to move out to try and compete against try to deal with the pandemic. But this also meant that premises were opening with restrictions such as fewer people, more spacing. You couldn't have any music on so that you didn't have spittle, therefore you weren't spreading the infection. So there was a lot more, it was a quieter startup. Also, people were quite tolerant, it seems, to businesses having external areas. Whereas recently, public protection have started to receive a lot of noise complaints from residents in the city centre about external eating and drinking areas, where the tolerance appears to be waning now. Let's have a look. And we'd have concerns about this, especially because of the noise complaint, again, as I said. The second thing to consider is the management of the premises. One way to manage a premises is through demonstrating proficiency when dealing with noise complaints. Now, we did have that noise complaint in May this year. The noise complaint, whilst it was logged as one complaint, the complainant said this has been a regular issue of noise from the premises, from music blasting out and affecting them. When the complainant went up to speak to the premises about this, they asked for the noise to be turned down, and they were told by staff that they would not turn it down. So they did not turn it down. They did not deal with that complainant. I'm not sure it was logged anywhere that this had happened. And then as a consequence of this, the complainant came back to public protection to complain. This is not a good way of dealing with complaints and managing the site. The second thing of proficiency of managing the site would be the noise management plan. Now, the noise management plan should have been attached and submitted 1 month after the application about a year ago. However, no noise management plan was submitted. This, I think, also was linked to the external area, and we said we're okay as long as you put on a noise management plan. No noise management plan was submitted at that time. That was almost a year ago. We had the noise complaint, and as a part of our discussions with the applicant, we asked them to submit the noise management plan again. Again, they did not submit the noise management plan. We then had this variation application without any noise management plan attached. After submitting this variation application, they then submitted an application. They then submitted the noise management plan. This plan was not fit for purpose, so I asked for it to be reviewed again. Under this revision, there are still a few parts, as John Walker has said, which are missing, which need to be addressed. Not particularly major, but there are a few parts which need to be changed on there that we asked to be addressed, which were not addressed. There are also some parts I disagree with, for example, having music in the external area, because it raises the voices in the external area, therefore puts pressure on people raising their voices and impacting on public nuisance. I also don't agree with the 90 dB level which was put upon this application and in this noise management plan. And there are some technical difficulties with controlling noise from the premises. And this all needs to be agreed. At the moment, this noise management plan hasn't been agreed, and they are still in breach of their licensing condition at this moment. The other concern which has been drawn to here is the recorded music. I will work my way through this because there's been a few things said here as well about the noise levels. For the inside of the premises, recorded music, as far as the licensing regime is concerned, when you're applying for it on the premises license application, it is for louder music. It's for DJs. It's for very loud music indeed. The noise draft management said that they were going to have 90 dB as a reasonable background noise level. 90 dB would be a very noisy nightclub, so it wouldn't be reasonable at all. This level would be over the 85 dB level, which is the second trigger for the health and safety guidance on the control of noise at work regulations 2005, requiring them to do hearing tests and hearing protection for staff. 90 dB would fly through the windows. It would probably come through the windows of the premises. It would certainly fly through the door. They said they put in double doors. They have put in double doors, but this is by no way an acoustic lobby, because there's gaps in there, so the sound is still coming out. If you have level of recorded music, which is at 90 dB, then this can have hearing threshold loss for the customers inside there, because as they're in there trying to compete with the music, they end up raising their voices. As they come out of the premises, you get two things happen. You get the hearing has a temporary loss in hearing, and therefore you raise your voices to hear and people start shouting. So if the committee are minded to grant this application with recorded music without any further controls in place, you will then end up with a situation where you'll probably get noise breakout through the windows, certainly noise breakout through the double doors. You will get people coming out onto the street with raised voices 7 days a week in the CIA up till 1 o'clock in the morning. And public protection would just absolutely put in a representation against that and would advise that it was refused on the grounds of public nuisance. However, the applicant today said that they want to have just background music. And as has been said already, if you just want background music, then you can just refuse that element of this application and just have background music. There would be no need to have the acoustic lobby changed or move or work any work on that. And we could still work on the noise management plan and get that in place. You wouldn't get the hearing threshold loss and you wouldn't get the people shouting outside, but the applicant would have to agree to that. My concern here is that in our meeting, he said that he did also want to have louder music later in the evenings after 10 o'clock and for birthday parties and things like that. So he's saying he wants just background music in this hearing, but then he's saying that he wants to have it louder. Now, with the louder level of music, he's expressed a level which was around about 83 dB inside. It's not too loud. You would still have to raise your voices. There would still be noise escaping out through the acoustic lobby. And there might still be a risk of hearing threshold loss, although it would be to a lesser extent. Public protection, in principle, would actually also support that 83 dB level. But again, you've got the difficulties with the setting level. When we went down to site, the noise limiting device, we could not set the level upstairs and downstairs without the staff downstairs being able to overrule the level that we set upstairs. I think this can be dealt with, and I think we can overcome that. But the concern comes down to how long is that going to take? It's taken over a year to get the noise management plan submitted. It still hasn't been agreed. We're still in breach of that condition. How do we safeguard that they're not just going to have loud music with people coming out later in the morning, shouting with noise escaping out through the doors because the work hasn't been done, the noise management plan hasn't been agreed? How do we do that? It would seem from this meeting today that there are three options. There is, well, almost two options. Refuse the regulated entertainment at all, because the applicant says that they want to have it just as being background. If they can clarify that, then that would be one way. Refuse the regulated entertainment. It's not required. You just want it as background music. No work is required. Alternatively, if they do want to have that louder level, and if you are minded to allow that, we need to have an extra condition put on here prohibiting regulated entertainment from taking place until the noise management plan has been signed off and until any works have been carried out, for example, the acoustic lobby and setting this level with the noise limiting device. Otherwise, you'll end up in a situation whereby they can run it as a nightclub 7 days a week. I hope that is clear. Just please ask me if you need me to clarify anything on that. In summary, again, I would say public protection do not support the escalation of time in the outdoor area upstairs, as this would put pressure on the CIA. We do not support the extension of the recorded music until 1 o'clock without any further conditions being put on. And we would advise that that is either refused on the grounds of public nuisance, just to be background music, or you attach a condition requiring that the music is prohibited until we've agreed the noise management plan and done any works that need to be done on the premises to make sure that the sound doesn't escape. And that's it. Thank you.
Thank you. An opportunity for questions now. If Mr Simsek or Mr Walker have any questions for public protection.
I will, sorry, John. I will need to tell you this, Mr. Michael.
Sorry, just 1 second. If it's a question, then now is your opportunity for that. If it's kind of additional representation that you'd like to make, you'll have an opportunity at the end to sum up.
Well, I need to give some
you have-
answers though. It's,
well, if it's answers to anything that's been raised in the hearing, then would you mind adding that to your summing up at the end? Now
Okay,
is
that's
specifically
fine.
for questions
fine.
relating to Michael Golightly's representation, if that's okay.
Okay.
Yeah, any questions?
Just a couple of points for Michael. Michael, have you had any complaints from anyone other than just this one person who you refer to in your evidence?
No, we haven't.
And did that complaint have anything to do with the use of the first floor terrace?
No, it didn't. No, it was to do with music, which was at the premises. There's some question as to whether it was inside music, which was coming out, or whether it was speakers which were outside, in the outside seating outside.
Yeah,
I can't clarify that.
and is it fair to say that since I got involved with the noise management plan, that we have actively taken steps to try and resolve that issue in a positive way, and have dealt with it in a very prompt manner?
It's a bit that's a bit difficult because it wasn't quite up to scratch really at all as a noise management plan. The parts which I'd expressly asked to be put in there weren't put in there. Some parts which didn't need to go in there were still put in there. The plan that I asked to be put on to see where that was hasn't been put on. So there's all these different things in there. It's work in progress, and like I said, I think with some safeguarding for the internal levels, if that was to be done for the internal music, it would still need a condition on there just to make sure, just to ensure that this doesn't go on and on and on. I mean, even when that submission was asked to be redone, it's coming almost a month after our comments initially on the noise management plan.
And so, just to finally confirm the point that you made, that you would be prepared to accept a condition prohibiting recorded music until the noise management plan was signed off.
Yes, because that way, if it doesn't get signed off or we can't resolve these technical issues, then it just stays on as being background music. If he does want to have that level, the level that he expressed, which was around about 83 dB, there would still need work on the acoustic lobby, but yeah, it's something that we would be able to work on.
Yeah, so just to clarify, given the fact that the work management, the noise management plan is clearly a work in progress, our client, in your view, and I have to say, I can see a lot of sense in it, would either have to accept that he'd have to accept a condition that was linked to the signing off of the management noise management plan, or would have to rely on his ordinary rights that aren't covered by this particular application. Just to make that absolutely clear. Yes.
Yeah. What it is that if the committee grant today the regulated entertainment as it is without any further conditions in there, he can run that as a nightclub at 90 dB. It's too loud for that premises, even by his own admission when we're down there. It's going to blast out through the door. It's going to come out through the windows. You're going to get people with raised voices. That is a significant risk because the amount of time it's taken to get all the other things done and in terms of the noise management plan and not getting things resolved really. So yes, my concern is that you need to have a condition on there to prohibit that until we are satisfied one way or the other that the noise management plan is being signed off, that we can set that noise limiting device without it being tampered with, and so that he has control over it upstairs, and that the acoustic lobby is adequate to prevent any noise breakout. Otherwise, we would just object to it, and it would have to remain as being background music only.
Would it be possible to make the building of some kind of a structure or barrier between the property and the neighbouring flat, which I think has been mentioned?
Oh yeah, I'm concerned about that. Yeah.
Part of a noise management plan.
For the external area upstairs.
Yes.
I would have concerns about that because you're looking, it's like a heritage area, and whether that's going to be allowed to put something up there which I don't like going about planning much. It hasn't been, it hasn't been agreed by that, and I don't think at this stage that we can put onus on that. We just have to look at it from the licensing perspective. It's in the CIA, and I think that's what we need to look at really here as a license application. I can't comment on that because I think it's outside of our control.
I've got no further questions.
Thank you. Any other questions from the panel for public protection? Yep, Councillor Galvin.
Can I ask, we've had one complaint and one, could assume it's the one that's the nearest to the property. How often have you had a complaint from that complainant? And I'm assuming, and can you confirm it's the one that is, I think somebody said it was 8 meters away from the outside area, the upstairs outside area. Can you just confirm that you've only had the one complaint, or is it, or has it been a series of ongoing complaints?
It was one complaint that we've received as public protection. It was the complaint was that it had been happening regularly. This is the thing, so you have to take it in context. The complaint is that this had been happening regularly, and again, it comes down to the management of the site really, which is our concern. Like, if they can have longer to demonstrate in a normal circumstance, not over COVID, which was difficult, and not with the different restrictions that you've had on because of that, with reduced people, not being able to have music. If they can demonstrate over a period of time, and a longer period of time, how they're managing that, we may be able to review it again. But this is, as far as we're concerned, within a year of them opening up, they've had that noise complaint, and the complaint was that it was a constant ongoing thing. And the element of the management of the site is that the complaint said that they were just completely ignored, so that there was nothing logged. They were just told, no, we're not going to do this, we're not going to turn the music down. And as a consequence of that, that's why they've come to us. But it was one complainant.
Thank you.
Thank you.
Councillor Wells.
Thank you, Chair. Can I just ask about the other half of the application, about increasing the hours for the roof terrace? When you were talking mainly about the noise from music. If the music wasn't granted, what would be your concerns about the impact of extending the hours?
I think you've got a few things really in the CIA. I mean, obviously you don't want to have like creep in the area, and when you're making a decision, obviously it's going to set a precedent on other licensed areas at such close proximity. When licensed areas externally have been so close to residents, we are really, really cautious that in the city centre of York, obviously you've got houses everywhere, that we know of one resident out the back. There may be another, we're not sure. We'll go with one. The problem is that after 9 o'clock, the tolerance level comes down, and then what you'll be doing then is increasing that anywhere else where the residential premises actually physically overlooks the licensed area. And that's what the situation you're going to have here. That premises only, the residential premises only has single glazing. I did manage to look at that. So they can't do anything themselves to mitigate from it. And it just isn't right for other people in the city centre to have to tolerate noise or unwanted noise after 9 o'clock at night. And you know, from 9 o'clock, that's relatively early in the evening. But once it goes up 9 till 10, 10 to 11, it starts to impact upon people. And obviously, as people there longer, they start drinking more. So it has that as well. So that can raise voices too. So the music is an extra element of there. It's not covered under this because it would be ancillary to it being open. However, it's just that general concern in general of being so close to residential. I'm very uneasy with it. And just saying, well, we've asked the resident, is that okay? And just letting, you know, you're almost saying to them, we're going to have some disturbance. Can you accept that? As opposed to saying, I'm going to make sure before this goes in that this isn't going to create any noise to that resident or the residents. Also, the noise can travel around, especially on quieter nights. This is another concern there. So Friday, Saturday, you've probably got a lot of noise in that area. Monday, Tuesday, Wednesday, it might be quieter, and especially as you go into 9 o'clock, 10 o'clock in the evening, that there are residents just to the front. You've got the flats above, which are raised up on the old building that's name I've forgotten what it is. The big building, you know, with the Baroque.
Stumble.
Thank you very much for somebody, for Stonebow. So that's up raised high on the balconies. They may be affected by it. You just don't know how it's going to travel, and especially late at night, it could put further pressure on the CIA. I think it is altogether that close, and there's certainly that close proximity to any residential.
Thank you.
We've heard that we've heard about the use of kind of double doors, which helps to limit some sound escaping. That there isn't double. Yeah, is that only referring to the ground floor entrance, or is there also double doors to exit out onto the terrace?
Oh, good point. No, yeah, it's only to the downstairs part. So there isn't. I'm not sure. You'd have to. I'm trying to remember when we went down to the site. It might be quite closed off upstairs anyway. I think it's quite separated off. Double check with Mehmet. I believe that's quite isolated anyway upstairs. There is stairways going up, but the noise should be mostly isolated to downstairs. My greatest concern was to do with the external noise breakout. There's a very short distance between the internal doors and the external doors, so it's very difficult to create an acoustic lobby. And at the time when I went down there was gaps down there. I would say my greatest concern was the downstairs doors.
Okay, well, there'll be an opportunity for further questions to the applicant later, so I'll ask them then. But yes, in terms of the use of that upstairs terrace, there may be. Are you concerned about music escaping? Because there can be recorded music played until 11:30 p.m. Are you concerned about recorded music escaping via the terrace, or is that
from inside? It's a possibility. It depends on what level they've got. If they go for the 83 dB or the background music, it shouldn't be an issue, in all honesty. If they go louder than that without any controls and they have louder music still, then yes, obviously there's a concern that it would go up the stairs and then travel out through those doors. It didn't strike me as too much of a concern, I'll be honest with you.
Okay, all right, thank you. Any final questions from the subcommittee to public protection? Sorry, John Walker, I see you have your hand up. Is it something that can be added to your
well, no.
summation?
It's a couple of ancillary questions which have come out of the answers that Michael's given in the period after I raised my questions.
Oh, okay. Well,
Relevant.
go on then. Yeah, all right.
So, Michael, could you just let us know where the person who made the complaint actually lives?
I'm dubious not to, because we don't like to give away any where people live. But what I can say, it was to the front down St Saviour Gate.
Right. So it was not the person who lives in the flat that is nearest to the property.
Not from that complaint. No, it wasn't.
Is it also fair to say that residents in Stonebow House and on St Saviour Gate already have any noise that comes from the ground floor of my client's property and from the terrace public house just across the road? And isn't also the case that this terrace, in fact, is behind the main bulk of my client's property? So in fact, noise is not going to travel down towards St Saviour Gate or Stonebow. It's actually hidden behind the bulk of my client's property.
Well, I mean, you've had complaint about the noise from which, as I said, I think it was from the front of the premises of this premises. So, I mean, they've already, added to the public nuisance by having that noise complaint and the noise that they've done out there at the front, with the seating area outside, with the noise management that wasn't submitted. But also, in terms to the other noise, again, as the police have said, you're adding extra on top. So you've got the external area, you've got the bar, you've got the other premises, and then you're adding this on top of that, including the area at the back. And I believe, on quieter nights during the week, there could be a risk of that being escalated, with this area being used at the back, even that just adding to that accumulation. Thank you.
Councillor Galvin, is that a further question for public protection?
Yes, it is. And there used to be on the end of Spurrier Gate, sorry, St Saviour Gate, a taxi rank. I don't know whether that's still there or not. One would assume that given all the noise, etc., that's being created, that's been removed. Has it been removed or is it still there?
I don't know, Councillor. You would have to ask the licensing team who might be able to clarify that. I'm sorry, I really don't know.
I think it is still there, but if Leslie Cook wants to answer that question.
Sorry, Councillor, can you just repeat that? What's still there?
The
Sorry,
taxi
Leslie,
rank.
there was a
on St
taxi
Saviour
rank.
Gate.
I'm looking at the map.
Oh yes,
now.
that's still there. St Saviour Gate taxi rank is still there.
So that's opposite.
Sorry, I keep breaking up a little bit. Yeah, it's still there. Is St Saviour Gate.
Fair enough. It's roughly opposite 1 to 7 St Saviour Gate, I would have thought, behind that little bump in the footpath.
It goes down as, yeah, it starts outside the side of Stonebow House. It virtually is the full length of Stonebow House.
Right.
Is the
Okay.
taxi rank.
Thank you. Yeah.
Mr. Walker?
Sorry, I just wanted to amplify the point about the taxi rank. The taxi rank is there until very late at night, early in the morning, with a lot of people.
Okay. Right. So this is something
Chair, sorry, if we're able to comment, I'll be happy to make further comments.
So
are we just doing questions or are we closing that off now?
Just questions now, public protection. Okay. Everyone will have the opportunity to make any further points. Everyone will have the chance to sum up at the end. And if there's anything else you want to add that is as a result of things that come from the hearing, then there'll be an opportunity to do that then. Yes, any final questions for public protection? No, I'm not seeing any more hands. Okay, so the next representative is the Licensing Authority, Helen Sefton. If you could try to keep it to 15 minutes maximum, please. Thank you.
I certainly won't need 15 minutes, but thank you. Yes, good morning, everyone. Yes, it is some morning. Good morning. You've obviously heard already from my colleagues who are the experts in public nuisance and prevention of crime and disorder. And the Licensing Authority would like to point out that we do fully support the comments by both of the other representatives. As they are the experts, they have given you a much clearer picture of what this variation would mean to an application within the cumulative impact area. So I will be quite brief. As has already been stated, the premises was first licensed at a hearing of the subcommittee in 2018. And the premises does lie within York's cumulative impact area, and it was adopted by the council in March of this year. The policy does state that applicants for new licenses or variations within this area should normally be refused, unless the applicant can demonstrate how the proposals will not add to the issues already being recorded within this area. This premises and its operator has already been before the licensing committee on 2 separate occasions. And each time, I believe the applicant has failed to show how the premises will not add to the cumulative impact in the area. As I said, the premises was licensed first in 2018. The subcommittee at that time restricted the use of the rear roof terrace to 2100 hours. Once it was licensed, and this premises was previously a barber shop, it did not operate for some time. I am aware that the premises was still operating as a salon or barber shop during July-August of 2020. In summer 2021, the operator applied to vary the licence to increase the hours of the roof terrace from 2100 to 2300. At that time, responsible authorities, police, public protection and the licensing authority all made representation, as did neighbouring properties. Because the applicant chose to withdraw the part of the application that referred to the roof terrace, all the responsible authorities accordingly withdrew their representations. The neighbours did not, and therefore the variation came before the licensing subcommittee at that time, and the restrictions on the roof terrace remained in place. This new variation before you today seeks once again to allow the roof terrace to open to 2300. And whilst the operator is described in the application as running a tight ship, it is disappointing to note that despite being made aware of the need to vary the licence 1 year ago to take into account a change in layout of the internal ground floor, the applicant has failed to do that. And this is a breach of the Licensing Act 2003. Furthermore, at the last hearing in 2021, the subcommittee imposed a condition requiring a noise management plan to be submitted to the satisfaction of the licensing authority by the 28th of October 2021. That document has only recently been submitted and it is yet to be approved. Accordingly, the licensing authority would like to see a good period of time pass whilst the noise management plan is actually in place before we can determine its effectiveness, and in so doing determine whether the roof terrace will add to further instances of public nuisance and therefore undermine one of the licensing objectives. I don't propose to say anything else, but I'm of course happy to answer questions.
Thank you. Yes, Mr Walker and Mr Simsek, do you have any questions for licensing?
I think got one question perhaps for Helen, who knows about licensing, etc. Is it the case that there's something called the Midnight Friar that has a late night refreshment license until 3:30, which is parked directly outside my client's property?
There is a late night refreshment vehicle outside the property. I couldn't confirm the times without researching that. I don't know them off the top of my head. We have far too many for me to remember them all, I'm afraid.
And that is in the lay-by directly outside the property. Is that right?
It is, yes.
Thank you. That's my only question.
Thank you. Any questions from the panel for licensing? No. Okay. Okay. Right. So that's all the representatives have made their representations. So there's an opportunity now to sum up, and we'll go in the reverse order of how we've done everything. Well, yeah, representatives and then applicant going last. So if there's anything else that if you'd like to sum up your case or make any additional points, that have come to light as a result of what's been discussed, and there's an opportunity to do that now. If we could start with the police, if you could try to keep it to 5 minutes if possible, please.
Thank you, Chair. I most certainly will. I think to summarise from our perspective, you've heard an awful lot about the policy and the reasons why we're all here making these representations. I think it's important to note from what's come out from the conversations and the comments that have gone back and forth that, as the applicant's solicitor has rightly pointed out, there are a number of licensed premises in this area. There are a number of venues that offer late night refreshment, alcohol, entertainment within this area. And that's why this policy has been written by the City of York Council. The cumulative impact policy has been written to talk about the saturation of these premises within this area. They are already there. What we're looking at today is adding further to that. So I think that's the important thing to take from this, is that this application is to add something further, something more, when we do already have so much within this area. And by that, we are definitely likely to be adding further to the impact on the stress and strain and on those licensing objectives. Your policy states that we shouldn't be adding further, and the applicant should be showing us how they're not adding. The applicant has only told us, well, Joe Bloggs down the street already has this. Well, we know that, and that's why the policy is there. We're asking how that's not going to add further to the strain that's already there. So we understand that there is a lot in this area and that it may not seem fair, but unfortunately that's the position that we're in. York is saturated with licensed premises within this area, and they do add greatly to public nuisance, and they do add greatly to the prevention of crime and disorder. Further to that, it's important to remember that we don't get complaints for things that haven't happened yet. We are here as experts to give you the information so that you can make informed decisions based on what we know is the likely picture, based on a lot of experience. if a roof terrace hasn't been open till 2300 hours, we can't possibly say that we've had complaints till 2300 hours because it hasn't happened yet. So that's something, again, that I will just remind people of. If it hasn't happened yet, doesn't mean that it's not going to happen. Just because we've only had one complaint at the moment doesn't mean that we're not going to get more. So we're looking at trying to prevent and make sure that we put mitigation in place to ensure that we don't add an increase. And of course, you know, we don't just work reactive to calls for service. We're trying to make sure that we have robust licenses in place to not add further and to not cause people those stresses and strains in the first place that they need to call for service. So I would just make a reminder to that and just ask you to very carefully consider your own policy and the advice that's been provided to you today to make a decision on the application. Thank you.
Thank you. Public Protection, Mr. Golightly, if you could go next, please. If you could sum up and try to keep it within 5 minutes, please.
Okay, thank you, Chair. Yeah, okay, so this is in the CIA, which is the cumulative impact area. This will be adding, as my colleague has just said, that will be adding extra pressure upon the area by adding more noise to this area. And that's something you need to consider. I'm also quite concerned about the close proximity to the resident at the back as well, because it's putting onus upon that resident to accept some disturbance, whereas really the applicant should be demonstrating that this isn't going to result in any disturbance happening to the resident at all. If that resident moves, somebody else moves in, you've got a similar situation. That person who moves in may not want any disturbance at all, and that needs to be considered. One person can be enough to be a public nuisance, and this would be adding to this. It would also be setting a precedent in the City of York, in the CIA, whereby other premises may want to extend their hours as well. As has been said, we haven't got any evidence of noise complaints after 9 o'clock because, generally speaking, that's a level we've found in the City of York, in the CIA area, that people can tolerate. And so that's for the rooftop area. We would just object to that on grounds of public nuisance, as it's going to add to the pressures on the CIA. For the music internally, it depends really what would you wish to grant. If you wish to grant recorded music, then if you wish to refuse that, you could refuse the recorded music element of it and just have it as background music. Therefore, no extra work is required. That they don't, you know, would be happy with that. It's not going to likely create any public nuisance. Alternatively, if you're minded to grant the recorded music, I would ask that you put on a condition requiring that the music is prohibited until the noise management plan has been signed off by ourselves and any works that are required are carried out. Alternatively, you may end up with loud DJ music every night of the week until 1 o'clock in the morning in the CIA. So that's about sums it really. We are not supporting the external area upstairs. We are not supporting regulated entertainment downstairs without any further condition on there to safeguard from that being used without having the noise management plan agreed and having any works carried out that are required. Thank you.
Thank you. The Licensing Authority, Helen Sefton, could you please make your summary representation?
Certainly, yes. Briefly, as has already been said, the premises is within the cumulative impact area. Our own licensing policy says that this application should be refused unless the applicant can show how they will not add to the cumulative impact in the area. At this time, the Licensing Authority do not feel that the applicant has done this, and so we cannot support this application. Thank you.
Thank you. Right, so there's an opportunity now for the applicant to sum up. I'll leave it up to you to decide how you're dividing that time, whether, because I know Mr Simsek, it looked like you had some things you wanted to add. I don't know whether you've been able to coordinate with your solicitor to add that into one kind of summary, or whether you want to both speak and divide that 5 minutes between you. I'll leave you to decide how you want to do your kind of final
perhaps the amendment would like to,
up.
perhaps if the applicant would like to speak first, Chair.
All right, that's fine. Yes, Mr Simsek, if you do have anything you'd like to add, and then your solicitor can also finish your 5 minutes of summation if you'd like to.
Yeah, yes, please. First of all, I have been listening everybody very, very carefully, but Mr. Golittle, when he was explaining, he explained things a little bit less than we should, because he said about 90 dB, and I explained to him once, twice, 3 times here, that was the mistake of my reading of the meter, my own. So I didn't want the 90 anyway. And although that one person from St. Xavier Gate came in, Mr. Golittle again said, we said no, we didn't put the volume down, and that happened. That didn't happen again, and that did not happen straight away. That has been done, and the guy hasn't been here since. So within about a year, we are talking about. If we haven't put the volume down and say, I said myself sorry so many times, and the guy left. That was it, and we haven't seen anything like that since. So some of the things that they end up like in my property, without all this happen, I can show you. I got 24 cameras in my building without anybody asking. I care more than you do care about my business. And I got all these. And you see, again, safety of customers and safety of, my future. So I do, and I will do anything to run my business and as quite peaceful as without getting across with the police, with the council, whatever. With myself, even last week, I helped the police, not Yorkshire Police, from this building at least 10 times, Miss Hollis, 10 times with my CCTVs. So I'm working very good with anybody and everybody, and I will carry on doing that.
Okay.
That's all I'm going to say.
All right,
Thank
thank
you.
Yeah, there are a few minutes remaining if there's anything else in summation that you'd like to say, Mr. Walker, or points to raise.
Just like to make a couple of very, very quick points. Simply to put this application into some kind of context, my client can already sell alcohol outside on the ground floor until 11 p.m. This is a tiny terrace that can hold 30 people, all sitting down and all having tables service. It's in a very, very, very busy part of York. Right outside is the taxi rank. Number of pubs in the area, people passing through it at all times of the evening. And this comes down to whether this application is going to have any effect on the cumulative impact. My view is that such a tiny application in a well-run premises in a very busy part of York is not going to have any material effect on the cumulative impact area whatsoever. And that an applicant like my client, who's trying his very best to run a business successfully in very difficult times, should be able to do so here. I take on fully the points that Michael's made about recording music, and I don't have instructions, but clearly a proper noise management plan has got to be in place before anything other than background music can operate from the property. We never try to argue that that is not the case, and we're trying to work with Michael to try and get that noise management plan in place. But it comes down, as I say, to you have to make a judgment. Does this breach the policy? My clear view is an application of this kind in these circumstances and of this nature and size is a reasonable application that is not going to affect the cumulative impact area. That's my submission.
Thank you. Okay, so everybody's had their chance to make their representations and ask questions and answer questions, etc. So I think we've had a full hearing. But are there any final questions or points of clarification from any other members of the panel for the applicant or any representatives or anything at all? You've got all the information you feel you need. Okay, excellent. Okay, so in that case, we'll close this hearing now and we'll go and hold our deliberations privately. And yes, we'll close this public hearing. We won't come back here to announce the decision, but all of you, everyone will be informed. All the representatives and applicant will be informed as soon as possible after we've made our decision. So thank you for your time today. Yes, and you'll be notified soon of the decision. Thank you.
Okay, thank you.
Thank you.